Business law is always tested on the REG exam, and contracts is a huge part of business law. And the CPA exam could ask you a sim on the difference between common law contract rules and UCC contract rules, Uniform Commercial Code contract rules. Now, most of the rules for the common law and the UCC are the same, but the exam likes to ask you where the differences are, kind of like US GAAP and IFRS. So let's start by going over some basics, the difference between common law rules and UCC rules with regard to contracts. Well, contracts will follow the common law rules if they're for real estate, services, and the sale of a business. Those contracts will follow the common law rules. Whereas if the subject matter of the contract was the sale of goods, then the UCC rules would apply and the common law rules would not. So if on the exam, real estate's being sold, you know that follows the common law rules. But goods are not real estate, right? Sale of goods would involve 100 cases of Snapple iced tea. That would be goods. Or computers being sold. Or handheld devices. Furniture would be considered goods. And goods will follow the UCC rules. But real estate would follow the common law rules, and so would services, and so would the sale of a business. So it's the subject matter of the contract that determines which rules apply. Now, we said earlier that most of the rules of the common law and the UCC are the same. A lot of the rules are the same for both. So the exam is going to test you on the rules where they're different. For example, offer and acceptance. If you're offered real estate, acceptance must be the mirror image, or it's a counteroffer. If you try to change terms, accept for less money, that's a counteroffer, not an acceptance. But under the UCC rules, acceptance with additional terms is okay. It's not a counteroffer, but a valid acceptance. And that's because you're selling goods, and it's normally between merchants who deal with each other all the time. So if one merchant offers another 100 cases of Snapple iced tea for $10 a case, and the other merchant says, yeah, I'll accept that, but I want 2% off if I pay within 10 days. The answer is that's an acceptance with the additional terms. It's not a counteroffer because we're under the UCC rules, which allow for acceptance with additional terms. If we tried that under the common law rules, wouldn't work. For example, if I offered you my bagel store for $50,000 and you try to accept if you pay me sooner, you'll accept and only pay me $40,000, that wouldn't work because under the common law, acceptance must be the mirror image of the offer, or it's a counteroffer. So that's a big difference in the rules, common law versus UCC, is how can you accept an offer? Do you have to use the mirror image language, the same language? Under the common law, you do. Under the UCC, you do not. So what are all these rules that are the same for both? I said the common law and the UCC, most of the rules are the same. Well, offers would have to be received in order to be valid. You can't have an offer just by mailing it out being valid. Communication, everything has to be received, like an offer, a revocation would have to be received. So if I try to revoke my offer to you, you'd have to receive my revocation. Otherwise, the offer's still open. Rejection. If you reject my offer, I would have to receive your rejection. You sending me the rejection wouldn't be enough. I would have to receive it in order for the rejection to be valid. Only the acceptance is valid prior to receipt, and that's known as the mailbox rule. And that's the same for common law as UCC. So if I offer you my bagel store for $50,000, that offer is not valid until you've received it. If I try to revoke the offer, you'd have to receive the revocation. Otherwise, it's still open. You can accept the offer until you receive the revocation. Now, if you want to reject my offer, you can send me a rejection notice, and that rejection isn't valid until I received it. But if you want to accept my offer for a bagel store, that's the sale of a business, you would have to use the mirror image language and accept for exactly the $50,000 that I offered it to you for. And then when's it valid? As soon as you drop it in a mailbox. But we know the mailbox rule is not always going to work, because if in the offer itself, if I say acceptance must be received by February 1st, then it doesn't matter when you mail it. It matters when I receive it. All right, let's try this question. The UCC sales article applies. A says to a contract for personal services. No, because if the subject matter is services, the common law rules apply. B, to the sale of specially manufactured goods. Well, yeah, as soon as you see the word goods, the UCC rules apply, so B's looking good. Patents, no, patents aren't goods. D, to the sale of goods only if the buyer and seller are merchants. Well, the UCC rules would apply if the buyer and seller were merchants, but the UCC rules would also apply to the sale of goods if only the seller was a merchant and the buyer wasn't. So it really doesn't matter that one or both are merchants. The minute you're selling goods, the UCC rules apply, not the common law rules. Now, certain rules under the UCC only apply to merchants, but the UCC applies and not the common law rules the minute you're selling goods. So if they gave you a sim on the difference between common law and UCC rules, they'd give you a bunch of different scenarios, and you'd have to determine whether the common law rules apply, the UCC rules, both, or neither. So let's look at this one. A contract may be accepted prior to receipt of acceptance under the mailbox rule. Is the mailbox rule valid under common law rules? Yes. Did we say it's also valid under the UCC rules? Yes, because most of the rules for common law and UCC are the same, and the mailbox rule applies equally to both. So put an X in the both column here, because both common law and UCC apply equally to the mailbox rule, where you can drop a letter in the mailbox. It's as good as accepted. It doesn't normally have to be received first in order to be accepted. Now, there is an exception. We said if the offer states that it has to be received first, but the general rule is it's accepted as soon as you mail it, unless the offer states otherwise. Both the common law and UCC both agree. All right, let's try this one. It says applies to contracts for the sale of specially manufactured goods resold by a non-merchant seller. Well, the minute you see goods involved, you know it's going to be the UCC rules, not the common law rules. So put an X under UCC rules, because the UCC rules apply the minute you're selling goods, whether the goods are custom made, specially manufactured, or just ordinary everyday goods, whether they're sold by a merchant seller, a non-merchant seller. If the subject matter of the contract is goods, the UCC rules apply and not the common law rules. Because the common law rules apply to real estate, services, sale of a business, also intangibles like patents, the common law rules would apply. All right, let's try this one. Injured party can receive liquidated damages of any amount provided in the contract. So here, if you're going to have damages, there must have been a breach of contract. And the injured party, it's saying, can receive what's called liquidated damages, whatever that means, of any amount provided in the contract. So what do we know about liquidated damages anyway? Liquidated damages is a good idea to have in a contract to agree in advance what the damages are going to be if one of the parties breaches the contract. It saves you from having to argue about how much you lost because of the other party's breach if you agree in advance as to what the damages would be. And that's the good news about liquidated damages. It's a smart idea to have it in the contract. The bad news is it's not automatically enforceable by the court. The court might look at the liquidated damage provision of the contract and think that it's too severe. The court might decide that it doesn't bear a reasonable relationship to the actual loss and then set that part aside. So that means whether it's common law or UCC, the injured party can receive liquidated damages, but not necessarily of any amount. A better answer would be injured party can receive liquidated damages of a reasonable amount provided in the contract. So let's go ahead and put the X in the neither column, because neither the common law nor the UCC rules will allow an injured party to receive liquidated damages of any amount provided in the contract, but both common law and UCC rules would allow injured party to receive liquidated damages of a reasonable amount provided in the contract. One of the best examples of liquidated damages is when the AICPA decided to computerize the CPA exam. Now, it had always been a paper and pencil exam prior to Prometric getting involved. So the AICPA had to go out and find a company like Prometric to administer the test on demand. and they had an agreement in place with Prometric before it actually started, the AICPA was very uptight, very nervous that Prometric wouldn't finish on time getting everybody ready for the new exam format that was coming. So that they put a liquidated damages clause in the contract saying that if Prometric wasn't finished on time, they owed the AICPA millions of dollars in liquidated damages. And it would have been interesting to see if that liquidated damage award would have been upheld by the court. But as it turned out, Prometric finished early. They got it done, so it never came up. But the liquidated damage clause in the contract was such an unbelievably large amount that it would have been interesting to see if the court would have enforced it. How about this? Consideration is required to both parties in order to form a contract. All right, what is consideration? Consideration is what you get from the other party, and consideration is what you give up to the other party in order to form a binding contract. So yes, both sides need consideration in order to form a binding contract. So let's put an X in the both column. Because to enter into a contract with somebody, you have to get something and you have to be willing to give up something. What you get is consideration to you. What you give up is consideration to the other party. And whether you're entering into a contract for real estate, services, or the sale of a business, or even the sale of goods, common law and UCC agree that you need consideration to both parties in order to form a binding contract. All right, let's change one word and watch the entire thing change. Consideration to both sides is required to modify a contract, not to form a contract. That was the previous question, right? Consideration to both sides. Is it required that both sides get something in order to modify a contract, change a contract that already is legally binding? And the answer is only under the common law rules. For services, real estate, the sale of a business, if we want to modify, change the terms of a contract that already started, both sides would have to get something for that modification to be valid. But under the UCC, only one party has to receive consideration for modification to be valid. This is the one I think that they'd likely ask you. If I had to pick one of all the ones we did so far, maybe this one. Let me give you an example of how modification would work. Let's say I hired you to work for me for 3 years. So write this down. I'm going to hire you to work for me for 3 years for $100,000 a year. And you're going to work for me 5 days a week during the day and get $100,000 a year. Now at the end of the first year, you got your $100,000 and you come to me and you say, "Hey Darius, I'd like to change the contract. I want a little bit more money." And I'm like, "Well, how much more do you want?" And you say you want $20,000 more a year. And at first I say no, but then I reluctantly agree. But I say that I'll give you that extra $20,000 when we're all done with the third year. So you'll get $100,000 a year, and then at the end of the third year, that's when I'll give you the extra. Well, the third year comes and goes. You've collected $300,000 so far. And now you look at me for the extra. Do I have to give it to you? And the answer is no. Because under the common law rules, we both would have to get something of value in order for modification to be valid. Now, you were going to get something. You were going to get more money. But what was I getting out of the modification? Absolutely nothing. So that would not be a valid modification unless both sides were to receive something. But under the UCC, if we were selling goods and we modified the contract, only one side would need to receive something as long as modification is done in good faith. That'll be the answer on the exam. As long as modification is done in good faith under the UCC, both sides don't have to get something in order for modification to be valid. All right, let's try this one. The price of a contract is considered material and would void the contract should the price not be specified in the contract. What do you think? Would the price of the contract be material enough so that if it wasn't in the contract would no longer exist, it would fail? The answer is that's true under the common law rules. See, if we were selling real estate and I offered you my home and you accepted the offer, and then we go to have the closing, and nowhere in the contract is the price. Do you see how that would make the contract void? Because you would think the price would be one thing, I would think the price would be something totally different. And there would have to be a price in a contract involving real estate. And it would be the same for the sale of a business. Same problem, right? I offer you my business for a certain amount. You accept. We go to have the closing. Now you're supposed to pay me at the closing. But what's the amount? It's not in the contract. So that would be void because the price is so material to a contract like a business or a primary residence, real estate, or even for services. A services contract would have to have the price in it. It would be considered too important to leave it out. So why is the price not a big deal under the UCC rules? Because remember what we're selling under the UCC. We're selling 100 cases of Snapple iced tea. We're selling bushels of corn. We're selling goods, tangible, movable property. Well, if we're selling goods, then those goods have a market price, right? 100 cases of Snapple, you could get them $10 a case from me, $11 a case from some vendor down the street. You can get them probably for $9 on the internet. So if you and I had a contract where I was going to sell you 100 cases of Snapple and the price was not in the agreement, how much would you be expected to pay me? And the answer would be you'd have to pay me the market price. And that could be clearly established since we're selling goods. So for that reason, price is not material when it comes to the UCC rules for the sale of goods, but price is very material when it comes to the common law for real estate services and the sale of a business. Now I want you to make a note of this. While price is not material under the UCC rules, you know what is material? Quantity. Right? So if we had a contract for cases of Snapple, but the 100 cases part was left out, the number of cases was missing, well, then the contract would be void. See, the UCC doesn't really care that the price is missing, but the UCC would not allow the quantity to be missing because we can't really make up for that. But if the price is missing, we could just go by the market price. All right, here's another one on damages. It says injured party can sue for both compensatory damages and specific performance. We talked about liquidated damages in a previous one, right? But now we're talking compensatory damages and specific performance. What are these things? Compensatory damages have the word compensate in it. And that's what compensatory damages are designed to do. They're designed to compensate you for your actual dollar losses. What did you lose? How much did you lose? Sue for that. So you could always get that. You can always choose to sue for compensatory damages. Now, what's specific performance? Specific performance is where somebody was supposed to do something under a contract for you and they refused to do it. And now you're going to sue them not for money, but you want them to perform the way they promised to perform. And let's face it, if they do perform the way they promised they would, you wouldn't have any compensatory damages. So that means you can sue for compensatory damages if they don't perform, or you could sue for specific performance, but not both. You cannot sue for both under the common law or the UCC, so we're going to put the X in the last column here. Because you can't sue for both compensatory damages and specific performance, but you can sue for one or the other most of the time. What does that mean? Well, there are times when you can sue for specific performance and times when you can't. You could always sue for compensatory damages, but you cannot always sue for specific performance. Why not? Well, there's certain contracts that don't allow for specific performance. Why? Well, if you were supposed to do services for someone and you got sick, you got hurt, for whatever reason you either can't perform or would rather not, it wouldn't really help if the court forced you to perform when you really didn't want to. Because the theory is you'd show up and you'd do a terrible job just because you were forced into doing it, and that wouldn't help anybody. So specific performance is not available for services under the common law, but specific performance is available for real estate under the common law. Why? Because all real estate is considered unique, and if you wanted to buy my home and at the last minute I backed out, you might sue me for specific performance because you spent the last 2 years looking every weekend for the perfect house and you thought you found it and now you don't want to go back to that anymore. So you might ask the court to force me to perform the way I promised to, even though at the last minute I might tell you that my wife, she doesn't want to move because we raised our kids here and she just doesn't think that now's a good time. So I'm offering you $1,000 if you would just go look someplace else for a house. Now, if you take the $1,000, that's your compensatory damages. You can't sue me for specific performance. But if you say, no, I don't want the $1,000, I want the house, that's you suing me for specific performance. And it's allowed for real estate, but it's not allowed for services. What about under the UCC? Can you get specific performance? Only if the goods are unique. So if the goods are ordinary everyday goods, then you're not going to get specific performance. Then you'll get compensatory damages. You go out and you buy your goods someplace else. So if I was supposed to ship you 100 cases of Snapple at $10 a case, and at the last minute I didn't do it, you would go out and get 100 cases of Snapple somewhere else. And if you had to pay $12 a case, then you could sue me for the compensatory damages, the $2 a case difference, but you can't sue me for specific performance unless the goods are unique. But in this question, it says the injured party can sue for both compensatory damages and specific performance, and the answer is no. That can never happen. You can get one or the other maybe, but not both. All right, a firm offer would make the offer irrevocable, even without consideration paid, to keep the offer open. Well, the general rule for an offer is that it can be revoked any time prior to acceptance, unless it's a firm offer. A firm offer is an offer that remains open, even without consideration paid to keep it open. But a firm offer only exists under the UCC rules. A firm offer would be made by a merchant in writing that gives some type of assurance that the offer is to remain open. So here's where I send you a written offer to sell you 100 cases of Snapple at $10 a case. That offer remains open. I can't revoke that offer if I signed it, if it's in writing, if it's made by a merchant, and if it's for the sale of goods under the UCC. If I made you a similar offer for my house, a written offer, I sign it, I mail it to you, I tell you that the offer is going to remain open, that's not a firm offer, because a firm offer only exists for the sale of goods under the UCC. So if I make you a similar offer under the common law rules, you would have to pay me consideration to keep that offer open, and that would be called an option contract. Under the common law, I would offer you 30 days to be the exclusive buyer of my house or my business if you paid me $500. So if you give me $500, I'll give you 30 days. That's an option contract. That's what happens under the common law. If you don't pay me the $500, I could revoke the offer and sell it to somebody else at any time. But under the UCC, you don't have to pay me any consideration for that offer to remain open. If the offer is made by a merchant in writing for the sale of goods and gives assurance that it'll be held open, then no consideration is required to keep the offer open. It's irrevocable for the time period stated. If no time period is stated, it's irrevocable for a reasonable time not to exceed 3 months. So let's read this again. A firm offer would make the offer irrevocable even without consideration paid to keep the offer open. That would only be under the UCC rules, because under the common law rules, if you want to know whether an offer is irrevocable or not, look to see if there's an option contract in place. If there's an option in place, then it's irrevocable under the common law. If there's no option, then it's revocable. But under the UCC, you don't need an option. The firm offer makes the offer irrevocable even without an option. How about this one? Adding additional terms when accepting an offer creates a counteroffer and is not a valid acceptance. And that would be the case under the common law rules. So if I offer you my bagel store for $50,000 and you add additional terms when accepting, or you change any of the terms and you don't use the mirror image, it becomes a counteroffer and it's not a valid acceptance. Under the common law rules, for real estate, sale of a business, or personal services, you've got to accept the offer exactly as it is. Otherwise, what you're doing is making a counteroffer, making a new offer. If you try to change the terms under the common law, it's a counteroffer, not a valid acceptance. What about the UCC? Remember, under the UCC, you could add additional terms, and it's okay. The additional terms become part of the contract. So let's read it again. Adding additional terms when accepting an offer creates a counteroffer and is not a valid acceptance. That's not true for the UCC. Because under the UCC, if I offer you 100 cases of Snapple for $10 a case and you add additional terms like 210 net 30, you want to take 2% off if you pay within 10 days, that becomes part of the contract. Why? Because that's how merchants deal with each other when they sell goods. So the correct answer on the exam is that under the UCC, additional terms become part of the contract. But under the common law, you can't add additional terms or it's a counteroffer.